time, and one of the most important, and I would suggest to you that the start off must be proving beyond a reasonable doubt the identity of the perpetrator of the crime. And I would suggest to you that as the most important part of this alleged event, especially the case at Judge Berg's house, although there were other very sad victims, that Judge Berg, being very close in proximity, either within inches or a few feet of the perpetrator in this case, could not perform the absolute necessary thing that is necessary in this case, and that is the absolute positive of identification of the victim. The fact of the matter is, we do have emotion, we do have sympathy for the judge when it happened and his family, and neither he or his wife could positively identify the defendant, and that is, in fact, on the record. You have seen it yourself. Of the 50 persons who did testify, there, in fact, were 2 individuals who did testify, allegedly, to the exact perpetrator of the crime on Oak Street. And who were they? They were Williams and Adams. And the quality of their testimony will be very important, because it will be under your scrutiny to make a difference in terms of their believability, their bias, their reason to lie, and the fact that they are admitted liars. Those persons were, in fact, perpetrators, questioned by the police, and they maintained their innocence. They maintained that they didn't do this, and they all along knew that they were lying. In contrast to my client, who has maintained all along that he didn't do it, and he was innocent, and he was not the perpetrator on Oak Drive in the city of Detroit at Judge Berg's house. What is their credibility? What is their believability? I believe it's based upon what the deal was that they received. The fact of the matter is, when interrogated by professional interrogators who over several times made questions of them, that after a while, even a child would know if they were asked, who did you see Billy commit the crime? Eventually asked enough times, because of the inference to satisfy the people that were asking questions, eventually the perpetrators, Adams and Williams, eventually got the message that in order to help themselves out, they had to, and they were required to name Kevin Smith as the shooter and present, when in fact they had previously denied that they were there, previously denied their involvement, and in fact had substituted, once the facts started coming out against them, they had substituted another person for their presence. I submit to you that's very important. And also, you must also realize and understand that at the time of the shooting of Judge Berg, that he was shot with an instrument, a gun, which ejects a spent cartridge. Never have we heard anything about that spent cartridge and the analyzation of it that ties Kevin Smith and any weapon that he had to be a perpetrator or used in the perpetration of the crime having to do with Judge Berg. So I submit to you that as to Judge Berg's house and the event of that, my client courageously has maintained his innocence in this matter and come before you and vehemently denied that it was him. And I think we have established a reason to doubt the testimony of the other persons, Adams and Williams in this case, and that reason to doubt leads to reasonable doubt, which you have to judge to determine whether or not the presumption of innocence has been overcome or not, and if not, your sworn duty to Judge Kenny, when you were sworn in, is that you must find him not guilty of that. And also, You've heard some testimony with regard to Mr. Moran talking today about not only the charge of assault with intent to commit murder, but assault with intent to commit great bodily harm. Those are two separate and different charges. One is a higher, more serious offense with assault with intent to commit murder. The other one is a lesser offense called assault with intent to do great bodily harm. I realize that the judge, in fact, was shot and have admitted and acknowledged that he was a victim. But the fact of the matter is, he also said that the person, whoever it was, and we don't claim it was, in fact, Mr. Kevin Smith, could have, I suppose, aimed that gun at a different part of the body of the victim in this case, and instead of being shot in the head, shot in other extremities, which we all know are very dangerous to be shot in, the chest, the stomach, etc. It was, the person was merely shot, and I don't mean to minimize that, because I'm sure it was very painful. I'm sure that rehabilitation has been very long and arduous. I'm sure that there probably not only will be everlasting mental repercussions of it, but physical repercussions of that. But the shot to the knee or the thigh certainly was not with intent to commit murder. So, ladies and gentlemen, I submit to you that identity of the perpetrator of the Oak Drive cases is within reasonable doubt and causing a reason to doubt, causing you to strongly consider and to bring back a verdict of not guilty by way of the fact that the case having to do with my client and Judge Berg was not proven beyond a reasonable doubt. And now I'd like to move on to the other robberies. First of all, you know as well as I do that Mr. Kevin Smith was not positively identified by anyone in any of the other events of the case. You've heard, of course, about the jewelry store robbery in which Mr. Smith immediately upon practically taking the witness stand, made some acknowledgement, but he also, I think, was indicating to you, and I think importantly so, that the fact of the matter is that that was not a part of any agreement, that there were, in fact, sole, separate, and non-connected events that you've heard about the other things that Adams and Williams and Russell and other people had done in his absence, which, in fact, I believe you can easily see and say the chain of any agreement was broken, and that there was no conspiracy on the part of Mr. Smith as to those. And as a matter of fact, I think you can rely upon him to give him some credibility that he was not a part of and did not enter into any, in fact, conspiratorial agreement amongst or with anyone else, and that these other matters were strictly on an incidental, non-coordinated basis. The physical evidence in this matter, no one can absolutely say who was the person who pulled the trigger on these weapons. You heard my client, I think rightfully and truthfully say that in his house he had weapons which I think he admitted, and it has to be honestly established through his testimony, he was not supposed to have, but people come and go, went and gone in his house, in his household, that he did not give permission to do things with those weapons, and that he has truthfully told you how he did not participate and did not have prior knowledge with regard to anything that was to take place. No spent cartridges that are connected with, in fact, Mr. Smith, and this business about these phone calls and the like of that. Certainly, I think you could only call bravado. You can tell that there are persons of the streets today, of the neighborhoods today, who either are of their own element, have their own way of talking, their own way of speaking, their own language that seems foreign to many of us. And although we might not know about them, and they may be in fact shocking, okay, to some of us, that it appears to be ordinary. It might not be the way we talk, might not be the way we act. It seems to be rather usual for them, and once again, sympathy and emotion should not come into play in this case whatsoever. Once again, Kevin Smith himself testified in this case on his own behalf consistently with regard to his innocence, whereas the other defendants had said what they said and then changed their story when they were to get a sweet deal. They were to get the benefit of what it is that they would tell the police and come here and tell you ladies and gentlemen of the jury what it is that they believe that they did so that they could maintain their contract, okay, which was really a contract not only to and for themselves and for the prosecution, but also to help each other. And I say help each other because you will recall that the other two, Don Diego Adams and Mr. Robert Williams, and also Mr. Russell, were not only related by blood, but closer in relationship to each other than they certainly were to Mr. Smith, if any relationship, allegedly going back over many years. But when it came down to it, who did they throw under the bus? The person who was really the outcast in this particular case is the family and blood relationships, but Mr. Kevin Smith. So I would say to you, and the judge will say to you, in judging the credibility of the two persons, the two and only persons who positively identify Mr. Smith in this case, that you will judge their bias, you will judge their credibility, their believability, their reliability, the self-servingness of their testimony, and understand that their credibility as far as quality goes is greatly lacking, to the extent that it does not overcome the presumption of innocence on the part of my client. And with that, ladies and gentlemen, I believe that there has been reason to doubt presented to you in this case as to the identity and the participation or lack of participation in the events before you as the judges in this particular case as to Mr. Kevin Smith. There is reason to doubt. Judge Berg did not identify. Mr. Smith has himself denied being in any conspiracy. The lack of his participation in any events of this matter, and the consistency to maintain his innocence, and the insertion and the assertion of persons against him who in fact had a great deal to give, great deal to lie about, and you can hear and saw the fact that they really got bargains in which benefited and gave them reason to throw, once again, Mr. Kevin Smith under the bus. Once again, I thank you very much for your kind attention in this matter. We're in our third week of this case, and the defense has had taken every opportunity to speed this matter along as best and be as cooperative as we can. Once again, over 500 exhibits in this matter. I present to you that none of them directly point, except for the two co-conspirators in and of themselves, to Kevin Smith, that he maintains the presumption of innocence, that there is reason to doubt because of the identity issue, reasonable doubt in this case, and that he should have the continuation of the presumption of innocence, and the defense would ask you to return a verdict of not guilty of assault with intent to commit murder as to Judge Berg, assault with intent to rob to Judge Berg, and of course the conspiracy. Thank you very much. Thank you, Your Honor.
Thank you, Mr.